A very good morning and welcome to the Talk of the Town. This is Sandro Satyajit, and this morning we take a look at Faraz Shakotali speaking with the President's Counsel Geoffrey Alagaratnam on how laws cannot stifle an alternative opinion. Let's take a listen.
One of the pressing matters right now, Mr. Alagaratnam, is this anti-terror bill. Could you tell me what are the concerns that the legal fraternity has in terms of the proposed anti-terror bill?
Fundamentally, Faraz, as I see it, apart from the provisions of this bill, we know that Sri Lanka is a democracy, and the democracy means the people. And the laws were made to protect society, to protect the people. And if you look at it, the main complaint, I think the Bar Association has expressed its view very clearly, is that none of the stakeholders have been consulted. We've been talking for years about abolishing the Prevention of Terrorism Act, a draconian law which has been used mainly against political opponents and others. And we have been talking of repealing it and a reform. Now, there was a previous bill that was brought that was withdrawn. They promised consultations, they promised to consider all the opinions of stakeholders, but now this, like the other bill, also the online security bill, is just being put forward without any consultation with any stakeholders or the views of others. The main concern here is that, is the law made for man or is the man made for the law? That is the concern I have here. And for whom are these laws? Is it to genuinely protect society, the country and people? Or is it for some other purpose? That's the principal objection we have to this. The anti-terrorism law, one of the main concerns is the definition of terrorism. Again, it's overbroad, it's vague. Almost anything can be considered terrorist activity. For example, my criticism of the bill and saying the government has not taken proper steps to consult the relevant stakeholders can also be interpreted as an attack on the state or whatever it is. And you and I can be considered terrorists for discussing these things. That is the plain. Of course, you can never have an absolute definition of terrorism. And also, you know that, all over the world, there is a need for some sort of law to prevent terrorism, even if it's not prevalent to such a great degree at the moment. But when you have a vague definition, you put a lot of people in peril, and we know that the past experience shows that even the PTA was largely used against freedom of expression, people who spoke out, who criticized the government, political opponents, and even people who wrote poems, and people who wore tattoos which they thought were religious symbols, which are found to be the wheel of a ship. So all these type of abuses, many abuses took place, and I don't see that going away when you find the definition of terrorism in this bill. It's overbroad. And if you see, even the period of detention, a person can be kept for 2 months without judicial supervision, without the magisterial intervention, and can be extended further. I think it's far in excess of the citizen's right to liberty, freedom. So that, and also you have in the anti-terrorism bill, for example, you have curfew orders where there are broad powers given for the president to impose curfew orders. Whereas under the public security ordinance, you can impose curfew even without an emergency. So why do you need these type of broad powers under this anti-terrorism act? Then there are places like, he can designate places as prohibited places, and you can be arrested for being there. So what is the prohibited place? Even he can even designate this very newsroom as a prohibited place. What is the criterion? What is the definition? Or the Supreme Court?
So what you're saying, Mr. Alagaratnam, is that this is very broad.
Very broad.
Very broad.
And several provisions are covered by other laws which are sufficient for the purpose. Too broad. And then even if you look at a thing like prejudicial to national security, what is national security? You look at the determination, the Supreme Court determination on the Right to Information Act. The Attorney General successfully argued that economic security, economics and economic development is part of national security. So if you criticize, for example, the DDR, the debt restructuring, or any other economic measures taken by the government, you will be imperiling national security. So you could be a terrorist. And proscription orders against various groups. So there are a lot of, apart from the broad definition of terrorism, which can catch up almost any activity, there are other sweeping powers as to curfews, prohibited places, proscription orders, which fundamentally offend the rights of the citizens of the country as to freedom of expression, freedom of movement, freedom to practice your trade or journalism, whatever it is.
That's a wrap of Talk of the Town this morning. It's now back to the Morning Fix with Dom and Asanka.